Is your data secretly available to foreign governments without your knowledge? It might seem like a question straight out of a spy thriller, but the answer is more complicated than you might think. In our hyper-connected world, data flows freely across borders, often ending up on servers in countries with different laws and regulations than your own. This raises critical questions about who has access to your data and how it's being used. The reality is that your digital footprint, from social media posts to online shopping habits, is governed by a complex web of international agreements and national laws. Two such laws, the US Cloud Act and the European Union's General Data Protection Regulation, or GDPR, are at the forefront of this digital tug-of-war with profound implications for the privacy of your data. The Cloud Act and GDPR represent two distinct approaches to data privacy in the digital age. The Cloud Act, passed by the United States Congress in 2018, grants U.S. law enforcement agencies broad powers to access data stored on servers located anywhere in the world. This means that even if your data is stored by a U.S. company on a server outside the United States, it could still be subject to U.S. law enforcement requests. On the other hand, the GDPR, which came into effect in 2018, prioritizes the privacy and protection of individuals' data. This sweeping regulation gives EU citizens significant control over their personal data, including the right to access, correct, and delete their data. The GDPR applies to any organization, regardless of its location, that processes the personal data of individuals in the EU. The Cloud Act, which stands for Clarifying Lawful Overseas Use of Data Act, was enacted with the stated goal of modernizing cross-border data access for law enforcement purposes. Proponents argue that in an era of cloud computing and globalized data storage, law enforcement agencies need updated tools to investigate crime and protect national security. The law allows U.S. authorities to compel U.S.-based technology companies to hand over data, even if that data is stored on servers in other countries. This extraterritorial reach of the Cloud Act has raised concerns among privacy advocates worldwide. Critics argue that it undermines the sovereignty of other nations and sets a dangerous precedent for cross-border data access without adequate safeguards for privacy and due process. The lack of judicial oversight in the Cloud Act process has also drawn criticism, as it allows U.S. law enforcement to request data directly from companies without obtaining a warrant. GDPR is a comprehensive data protection law that aims to give individuals control over their personal data and harmonize data privacy laws across Europe. One of the key principles of the GDPR is the concept of data minimization, which means that organizations should only collect and process the personal data that is absolutely necessary for the specific purpose for which it was collected. The GDPR also requires organizations to obtain clear and unambiguous consent from individuals before collecting and processing their personal data. Taking back control of your data. The complex interplay of international agreements and national laws governing data privacy can seem daunting, but there are steps individuals can take to protect their digital footprint. One crucial first step is to be aware of the laws and regulations that govern your data, and to understand the privacy policies of the apps and services you use. While reading through lengthy privacy policies may not be the most exciting activity, it's essential to understand how companies are collecting, using, and sharing your data. Look for information about data retention policies, data sharing practices with third parties, and your rights regarding access, correction, and deletion of your data.